seem to have parts 1 and 2. Part 1 is lessons learned from the pandemic, which god awful. If you ever thought that there was anything sacrosanct about landlord-tenant law, that thought is dispelled. Nothing is safe anymore. Start with the thought, regardless of anything else, we always thought that our business was safe, that there was nothing that the government would ever do to leases and landlord-tenant that would stop us from practicing. It's one thing what they did in 2019 with the new law, but to just say, okay, you're on hold now. Nobody ever thought that that would happen, and it did. So we have to dispel ourselves of the notion that this might not happen again the moment either another pandemic hits, and pick your scientists, but I think most people are saying that once it happened once, it's likely, if not predictable, to happen again. So the science gets in the way. The other aspect, of course, is that government found a way of intruding into our practice. And once government finds a way in, government finds a difficulty to get out. So during the pandemic, we had a governor who issued executive orders. We had a legislature which just before the pandemic decided to give the governor all of that emergency power. That had not been in the executive law until February of 2020, when they saw what was coming and they said, well, our way of dealing with it is to not deal with it, so we'll let the governor do it. So Governor Cuomo was given extensive powers to put our practice on hold, or as I like to say, to pause the court system. The emergency powers went unchecked for nearly a full year until Governor Cuomo was forced out of office. And yet, the removal of those powers really was never related to anything that he did in exercising them. Apparently, the legislature was not upset or concerned about the use of executive orders. It was only when Governor Cuomo had other issues that the legislature stepped back in and took them away. And even when they took them away with a lot of fanfare, they didn't really take them away. They still exist to a large extent for another governor to use, and anything that was taken away could easily be given back. The extent of the executive orders and what they mean to us, I think Jim is also going to get into when he deals with some of the constitutional issues. Then we had administrative orders by Administrative Judge Lawrence Marks. I like to correct myself there because he is an administrative judge, which does not give him the power to tell other judges who hear cases how to do things, and yet he did. And one of my other topics later on is going to be the secret memos and where they stand now. So anybody who was following landlord-tenant law, especially up here in Westchester County, was aware of the various administrative orders, memorandum, guidances, and other things that we just don't know about, that the courts were getting bombarded with on a regular basis. I can't tell you how many clerks I spoke to during this period who said to me that they gave up. They found that there were too many. It was happening every day. And then what we found was that the judges, to a very large extent, also gave up. There did seem to be a practice, I won't say a practice, but a reality that judges weren't reading the law. They were waiting for the administrative orders, for the guidances, for the memorandum to come out to tell them what they should be doing. And even when they did read the law and realized that there were things that were going on that weren't in the law, that they were told to do, they went along because they were told to do it. So they followed suit. In addition to the executive orders and the administrative orders, we had legislation. There was the Tenant Safe Harbor Act, CFPA, and ERAP. And yet, by and large, there was no hue and cry. Landlord groups barely let out a whimper in opposition to any of this. So where are we? Well, the good news is that the courts are back up and running. They've given up their plexiglass. Most courts now do not require masks, and many judges don't wear masks. I happen to. I have other reasons for that. But most people coming into the courtroom don't wear them anymore. But what we do have, even though we have trials and motions being decided, we still have short calendars. We have limits on the number of cases that any one particular landlord can bring on a particular day. We find out that next available, which used to be a phrase heard only in New York City, is now something that we deal with. Next available being, when does the court have room to put us in? So Yonkers is still giving out dates. Mount Vernon and New Rochelle have limits, and the time lags can run anywhere from a couple of weeks to several months still. Since 2020, we have new judges on the bench, and for 2 years we had no idea whether they were good judges, bad judges, read the law, didn't read the law, knew anything about landlord-tenant law, because all they were doing were adjourning cases. Now we're starting to get motions heard and decided, and we're actually getting some substantive idea of where judges fall out. We are also finding that some judges are finally getting tired of the administrative orders. They would never admit that, but you'll see later on when it comes to ERAP, there are many courts now who say, administrative judge, administrative order, nah, he can't tell me what to do. We're going to decide these even though we're told not to. So that's a good thing. Now, again, what have we learned? Well, we learned that the Constitution is not what we all thought the Constitution was. When Cuomo first came out with his executive order, everybody said, it's got to be unconstitutional. It's got to violate the contract clause, the taking laws, due process. And yet, if you read the cases, and Jim will go into my particular case, you'll see that the funny thing about constitutional law is everybody cites the same cases for opposite propositions. So the bottom line is that when it comes to these constitutional issues, at least in our business, the courts are going to follow what they think the present public policy is going to be. No federal judge on this level wanted to be the one to say that the New York State attempt to keep people safe was unconstitutional. Governor Cuomo found out what happens when the political backlash comes around, when unfortunately people are impacted by the pandemic, even if what's being done is not correct. So government action taken ostensibly towards protecting the public will not be struck down unless it deals with religion. It's the diocese case in Manhattan that said that, okay, if people can go out and protest, then constitutionally it is invalid to tell people that they can't go and pray. That's really the only constitutional issue that I saw where a plaintiff actually got relief. We have found that our three branches of government do not check and balance when it comes to this. The legislature gave up its lawmaking obligation to the governor. The governor did what he did, and the judiciary refused to do anything about it. Maybe it's all for the better. Maybe we should be happy that the government actually stepped in and did something that it believed was correct and necessary to protect us from COVID-19. But if we took a poll, I think our results would not support that conclusion. I do see that the door is now open, that a new governor, a new chief administrative judge, or even the present ones, might not just do the same again, not necessarily because of a pandemic, but because it's politically expedient to do it. As a practical matter, I say to you all, diversify your practices. I've said to many people, if in April 2020, Governor Cuomo said, I'm going to shut down the courts for 6 months or a year in order to get COVID under control and to help out tenants, a lot of practices would have closed during that time without any amount of income. So we now have to revisit what we do and how we do it. But for the fact that he was only extending these moratoria for 30-day periods, during which the clients were ready and willing to revamp and get going again and serve notices, a lot of lawyers would be out of business at this point. So what would have happened to our practices? I don't know. But if the question is now, what should we as attorneys do to protect ourselves? Then the answer is either get out of the business or diversify. Could we survive this again? I hope that we never have to ask that question. Then I don't know if you want to do any questions here, or I should just go on to the next section.
You can continue to the next section. I only have one question about what will be discussed. Oh, wait, I have another question. Do you still have to make a motion for leave to enforce/execute a pre-pandemic warrant in a commercial case or residential case? The NYC marshals don't know. Is it different in different counties?
Okay, so even though it's not on topic, the simple answer is in Manhattan, your system is utterly broken. Not Manhattan, all of New York City. It was broken before. It's even broken more now. I don't know the answer, quite frankly. It had always been the case during the pandemic that you needed to make a motion. I don't see any reason why not. To get a case back on that was ERAP control after ERAP A's, you got to make a motion. So I haven't heard anything that New York City has gone back on that, and you probably just have to do it. The other answer is just call the clerk's office in the county. They're very nice people whenever I've had to deal with them, and they would tell you, but my suspicion is you still got to make the motion. All right. Part 2, returned to normalcy. So as we all know, in 2020, the courts basically closed down to evictions. That pause was extended, modified, rephrased several times over 2.5 years. Courts were closed, but they did virtual appearances, created administrative calendars, made new requirements to deal with, and are continuing to deal with new laws. Executive orders, administrative orders, CFPA, ERAP, and the TSHA, Tenant Safe Harbor Act. And don't forget the HSTPA, the Housing Stability Tenant Protection Act from 2019. So for lawyers who have come into the business over the last 2 years, this is normal. This is the only thing they know. So they know that ERAP runs everything at this point, and it doesn't, in their minds, this doesn't seem to be so bad. For attorneys who are long practice, I don't even remember what normal was. How much did New Rochelle give in legal fees? I couldn't tell you. So if we define normal as simply being able to represent our clients within the parameters of existing substantive law, whatever the law, those laws are, we're certainly getting back to normal. We're not there yet. As we know, Yonkers still has an administrative calendar for pending ERAP cases, something I think they should have done a long time ago. They started doing several months ago. Those cases get put over until ERAP makes a decision. On the one hand, you can't bill for the appearance. On the other hand, it opens up the calendar, which I think is much more important at this point to get our clients' cases back up and running. New Rochelle still dismisses petitions where ERAP has covered the petition rents without giving any opportunity to amend. I was in New Rochelle this morning, and there was an attorney who had a case on, he couldn't understand. The judge dismissed this case because ERAP covered the rents that were in the petition without giving him an opportunity to amend. When you're faced with that, by the way, make sure, because there are two things going on. You have the petition amounts, the rents due under the petition, and the physical amount that the landlord is seeking. Just because ERAP pays more than the amount does not mean that the petition is satisfied. You want to really make sure that you don't have anything that was in the petition, a particular month, that was not covered by what ERAP paid. And since ERAP tells you how to apply the rent, you know the months that ERAP is applied to. Make sure that you got something left, and then even in New Rochelle, they won't dismiss the case. Many of the smaller courts are totally lost and confused, as many of them had been before when it comes to LNT cases. That has not gotten any better. The appellate term, which we all used to turn to every now and again, has adopted much more formalistic approach to appeals, closer to practice in the appellate division, where both sides are represented by counsel. So instead of relying upon the record of the lower court, which just got forwarded to the appellate term, they now want the record to be published in book form and served. And the cost there is going to become prohibitive for many landlords. It's so much easier to just start again. So in the past, we could have looked to the appellate term to give us guidance on what the law means. We're not going to get as much of that now. Not nearly as much, because there aren't going to be as many appeals. I went on the last several days, which I do every now and again, just to see what the appellate term is doing. There are almost no landlord-tenant decisions out of the appellate term second department. The first department is almost as slow to get back up and running, if there are even cases for them to handle. So we're not going to have the appellate term. We're going to be relying upon individual courts telling us what to do, and then those courts are going to have to figure it out. Has anyone heard of any plans that the courts may have fashioned over the past 2 years to deal with a similar situation? In other words, we know that this can happen now. We know what happens to the economy. We know what happens to tenants paying rent when there is something like a pandemic. I've not heard anything from OCA or the state or anyone else in the court system that they're coming up with a plan of how to deal with this so we don't run into the same issues that we had over the 2 years. Unless, of course, they were very happy enough to with what happened and would only reinstate it again if we ever came back to this. Tenant organizations are well funded and organized, and they are heard. But I don't hear that the landlords are being heard. We joked around about having landlord tax strikes. All the lawyers thought it was a great idea. Nobody did it. We thought that there would be a surge in doing tax certiorari cases by institutional landlords. I've heard of individual cases, but I haven't heard en masse that was done. It seems as though landlords are very happy to take what they can get. Most large landlords, although they were affected, were able to weather the storm. and don't appear to want to rock the boat. So if that was the normal, that's where we are now. Things have not changed very much. Jim?
Okay, thank you, Mark. Now, the first topic I'm going to cover is the expiration of the eviction and foreclosure moratoria. Mark alluded to these before. There was first executive orders, then administrative orders, then something called the Tenant Safe Harbor Act, ultimately the COVID-19 Emergency Eviction and Foreclosure Act, which one federal judge referred to as the unmellifluous SEPFA. And that sent me scurrying to the books to look up what unmellifluous means. And what it means is the opposite of mellifluous. Mellifluous is something that sounds good, like a beautiful voice singing a song. SEPFA is the opposite of that. It's difficult to pronounce, and nobody really understands what it means. SEPFA imposed moratoria on both residential and commercial evictions and residential and commercial foreclosures. What a tenant had to do to qualify for this moratoria was complete a hardship declaration. And at the beginning of SEPFA, the tenant only had to certify that they had suffered a hardship. It was just checking off a box on a form. And once that was done, that the court would then put the case off until the moratorium expired. That was challenged by a group of New York landlords successfully in the US Supreme Court. I'll get to the decision in a little bit. But what it ultimately did was it forced the state to go back and come up with some better procedures so that landlords could at least challenge a tenant's claim of hardship. So they came up with an amendment to SEPFA, which included standards. For a commercial tenant, they had to prove either a significant loss of revenue, significance not defined, but it could be on a case-by-case basis, an increase in necessary expenses for personal protective equipment, that would qualify them for a hardship. So you think like a retail store or something like that. Moving or relocation expenses, making it impractical to move. Now, that one, as we know, moving was considered an essential service right at the beginning of the pandemic. So the tenants couldn't say, well, I can't move. There certainly were enough vacant spaces that people could move to. So they couldn't say that, but the state focused on the costs. The costs are too high and I can't afford it. Now this only applied, the only ones who could take advantage of the commercial tenant hardship exemption were commercial tenants not dominant in their field. So for instance, Morton's Steakhouse or Starbucks would not be able to qualify for an eviction moratorium. Now the residential tenant hardship was significantly more complicated, but also much broader and many, many more avenues for a tenant to invoke a hardship. And that included inability to pay rent or other obligations or obtain permanent housing due to any of the following: significant loss of household income, again, not defined, but could be on a case-by-case basis. One wonders that if a student was working and contributing to the household, they go back to college, whether that would qualify the parents for a hardship. Increase in necessary out-of-pocket expenses for performance of essential work or related health impacts. That would probably be due to, focus more on first responders and people like that. Someone caring for children or elderly, sick or disabled family members negatively affected the ability of that tenant to obtain meaningful employment or earn income. So caregivers could qualify for the moratorium. Increased necessary out-of-pocket expenses. Well, it's interesting because there's nothing in the law that says that decreased out-of-pocket expenses should be considered as part of a hardship, although many landlords took the position that it should be considered. And I happen to agree. If you weren't commuting to work, if you weren't paying for parking, paying tolls, that's a savings to you. But the state saw it differently. Other circumstances have significantly reduced household income, kind of a catch-all there. Inability to move because it would prevent a significant risk of severe illness or death from COVID-19 due to being over 65 years of age. Being over 65 could now qualify you for a hardship. Remember, you could file this. The landlord would have to file a motion to challenge it. By the time that motion gets heard, you probably have 4 months. So you're probably, even if you lose, you're probably in good shape. Another, having a disability or having an underlying medical condition, which may include being immunocompromised. Those are some broad areas that would qualify a residential tenant for a hardship. And really, what I found is it's the exception rather than the rule that the hardship could be successfully challenged. When in doubt, it seemed to me a number of the judges just sort of decided in favor of the tenant, where it was close call. Now, the other thing, and this was challenged as part of a number of court actions, the hardship declaration had to be filed or had to be served with every predicate notice and every pleading. And failure to do that could result in dismissal of your petition. So if you serve it with an original rent demand, then serve it with a notice of petition, serve it again with a notice of default, you could go on and on and on. And the tenant could still file the hardship declaration anytime until the warrant was issued. Then the stays ran until January 15th of this year. Last year on this program, I felt that the state would extend the moratorium through the election in January 2022. I was wrong about that. The state allowed it to expire. To Mark's point, there was no hue and cry, maybe a little bit from a few tenants organizations, but no widespread societal movement to say, no, tenants still need this protection. However, as Mark mentioned, there have been a series of hardships to landlords and to their ability to get their cases heard. And those issues, the courts have been chipping away at the backlog, but for the most part, the backlog remains in effect. And you occasionally file papers and get called from the court saying, there'll be, your court date will be out 2 or 3 months. And there's really nothing you can do about it. One of the things you have to do is try, like Mark said, you get on the phone with the clerks, you be courteous, you try to get them to help. if they are of a mind to do so, maybe they can. But that's the issue with the moratorium. It's over now. But to Mark's point, we're kidding ourselves if we think this wouldn't happen again. It happened due to the pandemic. Mark's point that the landlord's response was fairly meek. Many were willing to accept what they could get, particularly when the government started funding tenant defaults. And so it may very well be that the next economic catastrophe, or if the war in Ukraine starts to get out of control, there might be more moratoria coming, particularly if the economy takes a hit like it did during the pandemic. Okay, so let's talk about federal constitutional issues in landlord-tenant law. Most of us who do landlord-tenant law don't think of it as an area ripe with federal constitutional issues. And in looking at this, I probably should have phrased it differently. I should have said federal constitutional questions, because there were questions raised, very legitimate questions raised, that the court system seemed to brush aside. And we're going to focus today on two areas. One was the limitations placed on evictions, and the second was limitations placed on rent regulation, how much rent landlords can take and things like that. The rent regulation originated from the Housing Stability and Tenant Protection Act in 2019, which I don't intend to get into in any detail, but suffice it to say it went from a local option law covering just a few counties to a statewide local option. So Rochester, Buffalo, places like that can now take advantage of these rent control situations that they never had before. And the other crucial aspect, and it's one that I'm surprised wasn't heavily litigated, was that back in the 1950s, the US Supreme Court, and actually going back to the 20s, the US Supreme Court affirmed rent control as an emergency measure. Well, the Housing Stability and Tenant Protection Act no longer has an expiration date. It used to be good for 4 or 5 years and then had to be renewed. Now it's permanent. So, but again, I haven't seen any real litigation on that issue. All right, so the first case we're going to talk about is one Mark knows well, Elmsford Apartment Associates against Cuomo. This was a challenge to the original eviction moratorium contained in Executive Order 202.28. They challenged the effectiveness of this under 4 provisions of the Constitution: the Contracts Clause, the Takings Clause, the Due Process Clause, and the Right to Petition Clause. And this was probably the case where the landlord's arguments were best heard and treated best by the courts, although I'm sure the attorneys who represented Elmsford Apartment Associates, one of whom was Mark, did not feel that way. The other cases that came after it were much more harsh. Now, what happened here is that sovereign immunity was pleaded as a defense. You cannot sue the state in federal courts for money or injunctive relief unless it's an ongoing constitutional violation. And so the court found that the challenge to the eviction moratorium was not a viable federal claim, in a sense, saying it should have been brought in state courts. I understand the legal principle, but as a practical matter, you're going to ask a state court judge to overrule an action by the governor who appointed them. I'm not sure how far you're going to get with that. So in dealing with the sovereign immunity issue, the court said it's difficult to think of a greater intrusion on state sovereignty than a federal court instructing state officials on how to conform their conduct to state law. And what that quote was in response to was that in Elmsford Apartment Associates, they said, one, the emergency powers granted to the governor were not authorized by the state law. And second, the state didn't follow the proper procedures in issuing the moratorium and the executive orders. The courts did not buy that at all. Now, the next issue addressed were takings. There are two types of takings. There are direct takings, where a state or a municipality occupies your power, and then there are regulatory takings. The argument here I thought was very clever, that it was a direct taking because they dictated the right to be able to remove people from the landlord's property. And the federal court didn't buy the argument. I think even acknowledged that it had some creativity to it, but said, well, you're only restricting the circumstances under which tenants can be evicted, so it's not a taking. You still own the building, you still operate the building, you still get income from the building. As far as regulatory takings, the major case is the Penn Central case, which I'll get into in one of the other cases where the analysis was more extensive. And the court said it's a very heavy burden to prove a regulatory taking, and they didn't really make it. It just says you can't evict people right now, but you can still go for money judgments. But what I found a little bit troubling was the court's language. Because landlords understand that their contractual right to collect rent is conditioned on a compliance with a variety of state laws, their reasonable investment-backed expectations cannot extend to absolute freedom from public programs, adjusting the benefits and burdens of economic life to promote the common good. The plaintiffs in Elmsford Apartment Associates never said we should be free from government regulation. They just said this regulation goes too far because it prevents us from evicting tenants who don't pay or, for whatever reason. So the court then moved to the next argument, which is it interferes with contracts. And the court concluded that if the law serves a legitimate public purpose or addresses an economic problem, and the means chosen to accomplish it are reasonable, then there's no breach of the contracts clause. They felt that the landlords tried to argue that the security deposit, they don't have the ability to use the security deposit as payment of rent. And so the court felt, well, you can't really get at the security deposit till the end of the lease anyway. So a delay in bringing an eviction is not a problem. And last, the right to petition was sort of summarily dismissed by saying it's a mere delay. Now, the delay went on almost 2 years. So at some point, one has to think that it would make a difference. Now, one of the problems here was the landlords appealed, but by that time, the emergency or the executive order had been replaced by CEPA. And then the court dismissed the appeal as moot. So again, you have these sort of actions, and this was one of the problems. The state was imposing these short-term moratoria. You attack them, you challenge them, and the response is, well, it's temporary. And by the way, the moratoria you challenged is now expired. It's been replaced by a different one. So your case is moot. You got to start all over. Many clients don't like that. They don't like paying for the same work twice. And I don't think for the most part they blame their attorneys, but it shows an unfairness in the system. If you can't actually get at, you can't sue the state for money. You can't sue the state to challenge a moratorium. And if you do, you get dismissed as moot because it expires. It doesn't seem like it's a level playing field. And one thing clients really resent is the perception that the playing field is unlevel. Okay, Alabama Association of Realtors against the Department of Health and Human Services. This challenged the CDC's eviction moratorium. And this was, again, very narrow case, just like Elmsford Apartment Associates. And they had some pretty good success. They found that the Surgeon General had exceeded his statutory authority by imposing an eviction moratorium. They quoted the language relied on by the CDC. And again, there's very broad language in the first sentence. The second sentence seems to limit that. The court took this as a preliminary injunction case, and it found that because the second sentence limits the first, the CDC and the Surgeon General were limited in what they could do. Now, those of you who are lawyers and remember back to law school, that was what we were taught. That the first sentence lays out the general law. The second sentence starts to limit what can be done. However, as we'll get into in a second, the dissent disagreed with that. They found, the US Supreme Court majority found that the federal moratorium intrudes upon an area traditionally occupied by the states, so they made it a state rights issue. And in probably the most curious quote of all, one of the most curious I've seen in a Supreme Court case, the court concluded, preventing landlords from evicting tenants who breach their leases intrudes on one of the most fundamental elements of property ownership, the right to exclude someone else. And that made me think back to the day when I bought my first house. You know, when I bought my first house, I was walking around my yard and I thought to myself, I can't wait for somebody to come on my property and for me to say to them, hey, get off my property. And, you know, in all these years, I've never had to say, get off my property, but it's nice to know that the Supreme Court's going to back me if I choose to kick someone off my property. And I've never seen a case, by the way, that said that somebody has the right to exclude others from their property, probably because most of us understood that to be the case. In any event, 3 judges dissented, and it's important to know their rationale. Their rationale was that the CDC's order was substantially more tailored than its first one. So I guess that means it was less unconstitutional than the first one. And they also said it was less broad than crucifix, which I'll get to in a second. and which also was invalidated by the Supreme Court. And they read the second sentence as expanding on the first. I personally did not read it that way. I remember from law school, they told us, limiting language usually governs, but the Supreme Court minority did not feel so. So then we move on to Crucifix, which again went all the way to the US Supreme Court. It was a case involving 5 small landlords, owed between 10 and 29 months rent. So as you can see, some of these tenants were not paying before the pandemic and probably were using the pandemic as an excuse. So the district court in Brooklyn dismissed the landlord's challenge. They found that sovereign immunity prevents action in the federal court. They also felt that statutes like CEPA, which was enacted really in a secrecy situation in Albany because the public couldn't attend, was adopted without notice and an opportunity to be heard. They said the district court rejected that argument, finding that there's a post-enactment remedy, although this court did not provide one. They felt, again, the public justification to limit the spread of COVID-19 was a sufficient basis for the law. Again, the right to petition was invoked. They said the court rejected it, saying, you don't have the right to get all the remedies you want, but you have a right to get a money judgment. So take that and be satisfied. Also, interesting point, they raised the argument that you're requiring us to give the tenant notices of their rights. That's a violation of our free speech. The court did not buy that argument, and it was quite understandable why they didn't. In our law firm, we have a room which has a whole wall taken up with posters advising employees of their rights and how they can sue us. And so if there's no free speech issue there, there's none with giving a tenant a hardship declaration. Now, in the Crucifix case, the Supreme Court reversed in a rather short opinion, really only about 2 paragraphs, that said, where you give a tenant the right to certify their hardship and no opportunity to challenge it, this scheme runs afoul of the court's longstanding teaching that ordinarily no man can be the judge in his own case, consistent with the Due Process Clause. So that was the Supreme Court's take on the self-certifying by tenants of a hardship. The dissent, again, the same 3 who dissented, felt that the legal rights at issue were not indisputably clear, so we shouldn't be enjoining the enforcement of the statute, that landlords have not shown exigent circumstances. I mean, to me, someone who's not paying rent for 29 months and has shown no inclination to start making payments, that seems pretty exigent to me, but apparently not to the majority or the minority in the Supreme Court. The case was sent back. The court again looked at whether to issue a preliminary injunction against the enforcement of CEPA. The court refused to give that injunction, found that the landlords were not taking advantage of publicly available programs such as ERAP, and as a result, there would be no irreparable harm to the landlords. They felt the landlords should be mitigating their damages through challenging hardship declarations, through accepting ERAP money. etc. Now, the biggest case, or the most significant.
Sorry to interrupt. Before we get to the next case, can we have the
Sure.
first code?
Yes, the
Thank
first
you.
code will be lameness. Okay, am I ready?
You are ready. I typed it in the chat as well in case anyone missed it. Thank you.
All right. So there was the case of Community Housing Improvement Program against the City of New York. This one was a direct challenge to the Housing Stability and Tenant Protection Act. And there was a similar case filed here in Westchester by the Building and Realty Institute. Both of them kind of crashed and burned. And I'll get to what I think the reason why is later. The Community Housing Improvement Program, it's known as the CHIP case, was a facial challenge to Housing Stability and Tenant Protection Act, a facial taking, a regulatory taking, an as-applied taking, a due process argument, and a breach of the contracts clause. Now, when you read one little excerpt from the decision, starts out, the Supreme Court and Second Circuit cases foreclosed most of these challenges. Well, when you read that, you can tell the rest of it's not going very well for you. They said no binding precedent this court has found, or no binding precedent on this court has ever found rent stabilization to violate the Constitution. And even if the 2019 amendments go beyond the prior regulations, it's not for the lower court to reverse this tide. It would have been fine if they had stopped there, but they proceeded to analyze a bunch of other issues, and probably because they knew the case was going up on appeal. The court concluded that the 11th Amendment bars claims for monetary damages against states in federal court. And they felt, even though the Second Circuit has not ruled on this issue yet, and by the way, this case was argued a year ago and remains undecided. So we'll see, or at least there's no reported decision that I could find. We'll see how it goes. The overwhelming authority of the other circuits is that you cannot sue the state in federal court for a taking. You have to go through the state court system and seek review by the US Supreme Court. Now, again, someone once said that some judges are so impractical, it's incredible that they find their way to the courthouse. I found that statement to be kind of bizarre. Anybody who knows anything about litigation knows it's difficult to even get your case to the New York State Court of Appeals. How are you going to get it to the Supreme Court? Leaving aside the cost of getting it there, to get all the way through the state court system and then have to go into the Supreme Court, your odds of getting there are so narrow. It's really a remedy in name only. They felt there was no actual physical taking by these regulations because the landlords still own the property. They can still mortgage the property. They can use it. They can sell it. So they have what they call the bundle of rights that dysregulate the, rent control and rent stabilization do not abolish them. They do limit them. Another sort of juicy quote from this case that says, "It cannot be said that there is no such thing as a regulatory taking in the world of rent stabilization, and it remains eminently possible that at some point the legislature will apply the proverbial straw that breaks the camel's back." That statement was made in response to an argument that rent control on its face is unconstitutional. The court went on to say it is unlikely that that straw in question will be identified in the context of a facial challenge. So this is one of the problems with bringing a case like this. You have to prove under no set of circumstances would rent control be valid. That's a very high burden, and quite frankly, it's impossible to ever prove that. I do concede that the plaintiffs were probably looking at this case as saying the only way we're going to get any relief is if we get to the Supreme Court. So we got to make these arguments and preserve the record. And I understand that. They looked at, from the Penn Central standpoint, they look at whether or not there's a regulatory taking, the economic impact of the regulation, the extent to which it interfered with reasonable government-backed expectations, and the character of the government action. And in looking at these, it clearly dismissed them all. In fact, it went on to say, and we'll see this quote in another case as well, that you're in a heavily regulated area. You had to know that your investment-backed expectations would always be in doubt. I'm not sure I buy the rationale, but there is case law supporting it. Due process, again, it's certainly hard to see how this argument's going to succeed. Due process is to prove to establish a challenge to a piece of legislation, you have to prove there's no rational basis. There's always going to be a rational basis for something like rent regulation. The contracts clause, the court again did a fairly similar analysis and felt, look, this really deals with a legitimate public purpose and an economic and social problem. So I'm sorry, landlords, you're out of luck. And the next case, the Building and Realty Institute, that one was brought here in White Plains. Again, many of the same arguments. The court rejected the complaint on the 11th Amendment. It held that once a property owner decides to rent his land to tenants, the government may require the landowner to accept tenants he doesn't like. And that's fine as a quote. It's fine as a statement of law, but I'm not sure it applies to the case. They were challenging the amount of money the person was required to pay. So what does that have to do with whether the landlord likes them or not? It has to do with the economics of the situation. They argued that Housing Stability and Tenant Protection Act gives the tenants a life estate. The court found, look, it doesn't eliminate your property rights. It lawfully limits them. Well, again, this is the court's call as to whether or not these modifications are lawful. But they always, and again, in analyzing the due process, courts look at things like they can evict a tenant for violation of a substantial obligation, or they can evict a tenant for failure to pay rent, or they can evict a tenant to demolish a building or to use it for your own personal use. And these are fine as statements of law, but they don't deal with the reality of the situation. The reality is it's very, very difficult, and the state has made it more difficult to pursue any of these remedies, particularly during the pandemic when there was an eviction moratorium on. So it's great that you have these rights. You're not able to exercise any of them. And the court was not terribly impressed with any of these arguments. When it looked to the investment-backed expectations as far as a regulatory taking, the court said a property owner is not guaranteed a reasonable return. Again, it's a fine statement of law, but the landlords weren't saying they're entitled to a guaranteed rate of return or even a reasonable return. That the court's actions had gone, or the legislature's actions had gone so far as to deprive them of property rights. Now, the problem with these last two cases, the Building and Realty Institute, or the BRI case, and the CHIP case is, and I learned this many years ago from my days working for the city of White Plains. City of White Plains would get sued a couple of times a year on broad constitutional claims, whether it's that the sales tax was unconstitutional, or the one guy claimed towing his car without notice and an opportunity to be heard for being a scofflaw was a violation of his civil rights. Vague constitutional claims are very difficult to litigate, and the federal court is increasingly hostile to them. In this case, the Elmsford Apartment Associates, I felt, got a fair hearing by the district court. In the CHIP case and the BRI case, when you read the opinion, it was almost like the court was annoyed that the landlords were wasting their time pursuing remedies because they should just suck it up and deal with whatever lightning bolts the state legislature throws down from Mount Olympus. And that's really not fair, right? If you are a property owner, if you're a landlord who owns a 12-unit building, two tenants not paying rent is a serious problem. And your inability to evict them compounds the problem. And the delays inherent in the system further compound the problem. And the state regulating how much rent you can charge and how much you can increase further complicates the problem. So what do we do here? My experience was, and I've tried to adhere to this throughout my career, is if you're going to fight the government, try to fight them on the narrowest grounds that you can. Because taking on something like challenging a zoning ordinance as unconstitutional on its face is a very difficult burden to take. And I understand clients like to have all these great arguments before a federal judge. And they like to think, I'm taking this village, this town, the federal court, and I want to throw everything at them. And I want them to have to spend money to justify themselves. Well, when you get results like this, you have to really stop and think about whether or not it was worth it. Now, this case, as the CHIP case, this has been appealed. There has not been a decision yet. I don't know when one's going to be forthcoming, but it's entirely possible that the goal is to get to the U.S. Supreme Court, which is the only place they think they'll get relief. So those are things that I think we should be focused on as attorneys, to try to get the issues before the court, to try to do it on as narrow grounds as possible, because the broad-based frontal attack on a piece of legislation like Housing Stability and Tenant Protection Act is a tough burden to have. And if your client's willing to undergo that burden and is willing to pay the cost, that's fine. As one very wise lawyer once said to a client, I'll fight this case to your last dollar. And there's some truth to that. If a client's willing to invest everything and throw it all into the fight, that's fine. But generally, at some point, the client's going to get discouraged when they have no rights and you're trying to explain to them how they could own a piece of property and be stuck with someone indefinitely. And we're going to talk more about that in a little bit. But so what is the lesson we learned from this? Mark summarized it pretty well, that the Constitution doesn't mean what we all think it means. We all know that the government limits the right that we have to do with to do what we want with our property. And that's fine. We're willing to accept that because it also limits our neighbors. But where the court doesn't provide a vehicle for a redress of grievances, you have to question what these rights really mean. If your right to due process means that there's going to be unjustifying deference by a federal court to state statutes, then you really have no due process rights. Then you do not have equal protection rights. And that as a practical matter, while you have the right to file the papers and make motions and submit oral arguments, if the courts are not going to vindicate these rights, you've really got to question what these rights mean and come up with another way of trying to use those rights to your advantage. Okay, so at this point, I'll turn it over to Mark, and he can pursue his next topic, which will be ERAP stays.
Now we get into some of the fun nuts and bolts stuff. ERAP stays. ERAP legislation is very clear that upon the filing of the application by the tenant, an immediate and complete stay of all proceedings has been imposed, whether for non-payment or for holdover. If the application is filed first, then technically speaking, can't even file your proceeding. Everything is stayed, unless maybe there's an exception carved out to file a proceeding in order to make a motion to lift the stay, because otherwise it wouldn't make any sense. But we'll get to some of those cases in a minute. So the immediate imposition of the stay of the proceeding. Legislation is pretty clear. Following the ERAP payment, if a payment is made, there is a prohibition for 12 months against evicting the tenant based upon the expiration of the term, unless one of three exceptions exists. One is that the tenant is causing a substantial nuisance and or destroying the building, where the landlord wants the property for his own personal use, or the landlord wants property back for a family member's personal use. Now, along the way, several theories of asking for the stay to be lifted were starting to develop. And they were based primarily on what we'll call the inherent powers or the futility arguments. These theories did not get you anywhere during CFPA, which is what led to Chrysophus, and we'll in a second distinguish between CFPA and ERAP. But as time went on, more and more cases were open to the concept that a landlord has a right to at least ask that the stay be lifted. So let's deal very quickly with the whole due process issue. Under Chrysophus, due process was violated the Supreme Court felt, because the tenant did something, and at the end of the day, there was no plan down the road for a resolution of the issue. So the moment that the tenant filed a hardship declaration, everything was stayed, and it would just remain stayed for a period of time solely for the purpose of staying the case. ERAP, by contrast, has an end game. The tenant has an application for assistance to an administrative agency duly enacted by the state of New York. On its face, due process there is not implicated because it's not the tenant that's causing the delay. The delay under CFPA was clear that the tenant caused the delay because nothing else happened. Under ERAP, the delay is caused by OTDA not being able to process, or not willing to process applications as quickly as we would like. That's not the tenant's fault. That's the state of New York's fault. So we all know when you give something to, let's say, a court, you make a motion, and it takes the court 3 months to issue a decision. Your case could be stayed while that motion is being heard. Under the CPLR, technically speaking, the making of a motion for summary judgment stays discovery, setting aside the local rules for the moment. But under CPLR, that's what happens. So is due process implicated there? I don't think anybody would say so, and yet your case is stayed by virtue of something out of your hands because somebody else did something. But what I've seen or not seen is that anyone has treated OTTA in the same way that we all used to treat DHCR. If somebody filed an application with DHCR and you weren't happy with how fast it was going, you did an Article 78 proceeding to compel DHCR to issue a decision on your application, on your PAR, or whatever it was. I haven't heard of anybody who's brought an Article 78 proceeding against OTDA to compel a decision after a reasonable time has gone by. Nobody's done it. Exhaustion of administrative remedies, which you find across the board everywhere else in the administrative forum, nobody has raised that in opposition to an ERAP stay, to a motion to lift the ERAP stay. So somehow or another, we're treating OTDA differently from how all other administrative agencies are, and what the law requires, how you treat all other administrative agencies. Nobody's doing it. So there are a lot of cases that deal with the motions to lift the ERAP stay. I couldn't put them all in here. I picked a few that I thought were interesting enough that they deserved comment. Acti versus Gregory from 2012 is cited very often. The tenant filed for ERAP and then left, leaving behind an under-tenant who was not obviously part of the lease. The landlord moved on among other grounds to lift the stay under futility, citing Chrysophus. Didn't get anywhere there. Although the court lifted the stay, it did so because even if ERAP paid, would not create or recreate a landlord-tenant relationship between that under-tenant and the landlord. And because the whole purpose of ERAP was to preserve tenancies, the stay was lifted. Implicit in the holding is a conclusion that if the original tenant had remained in possession, the motion probably would have been denied. Barker versus Cruz, also from 2022. The landlord commenced a holdover proceeding after service of a 90-day notice of termination, probably a notice of non-renewal. Landlord argued that the rent was legally uncollectible. It's unclear why, but it could have been a basement apartment that was not provided for in the CO. But the bottom line is that the landlord could not collect rent even if he wanted to, citing to Acti, but not the court cited to Acti and other cases where recovery was sought for personal or family use, even those grounds are explicitly included in the ERAP legislation, at least post-payment. Ultimately, the court lifted the stay because, again, ERAP was intended to not harm small landlords who agreed to waive the use and occupancy and the desired possession for personal use. So we have so far two exceptions that the court are looking at. One is where there's no landlord-tenant relationship to save, and two is that they want to carve out an exception for small landlords who would be overly impacted by the continuation of the stay. Next case, Papandreou versus Arroyo. I can't even pronounce it, I apologize. Quote, the court must avoid an unreasonable or absurd application of a law when interpreting a statute. The ERAP legislation was not intended to act as a prophylactic statute, and nor was it designed to create a barrier preventing, again, small property owners from advancing litigation. Again, a second instance where if you're a small, unregulated landlord, you're going to do much better than a larger landlord or where the tenant is subject to some kind of regulation. And here, the ultimate goal was to terminate the tenancy based upon conduct. Though those grounds are not identified, we can presume that they did not rise to the level otherwise provided for under ERAP, because then there's a statutory right to lift the stay. Where the tenant intentionally causes significant damage to the property or is persistently and unreasonably engaged in behavior that substantially infringes. I can't even say all of this in one breath. On the use and enjoyment of other tenants or occupants, or causes a substantial safety hazard to others. And by the way, I've not seen a case where that language from the statute has been used to lift the stay, even after the fact. So it's a standard out there, but we're not quite sure exactly what it means. Nonetheless, the court found that the ERAP stay was created to deal with money issues, not intended to deal with conduct questions. So this court, at least, was more likely to lift the stay on a holdover case rather than a non-payment case, despite the clear language of the statute that deals explicitly with conduct. So they ignored that part, found that since it's a holdover, they were willing to at least listen. And also mentioned as the prior cases to unregulated tenancies. So, looks like it's mail time. Thank you. Racy versus Lopez, Yonkers City Court. The landlord argued that more than the maximum 15 months that were due, the landlord decided not to accept the rent, as well as the absurdity and inherent authority theories, the lack of funds argument. Because the application was made after ERAP had already put out there that it didn't have money that would have covered this particular application. Nonetheless, the court denied the motion. It held that the tenant had applied through ERAP, which is the Yonkers-based program, which would have provided up to 18 months rather than the 15 months that you can get under ERAP. The landlord appears not to have reached that level at the time that it made the application, so the application was denied. Federal National Mortgage Association versus Gaudet from Mount Vernon City Court. Court appeared to have accepted the due process argument. That was probably Judge Johnson. We all love Judge Johnson. At least where there were other indicators. Pre-COVID, post-foreclosure eviction, where the tenant had agreed in the stipulation to a firm vacate date, violated that stipulation by not moving out. COVID hit and everything else came along. The landlord wanted finally to get that person out, not a tenant. The court held, this court believes that a process whereby the tenant can self-certify financial hardship without any challenge is not fair to landlords. The court opines that all applications for ERAP should be subject to judicial review when there is a good faith challenge by a petitioner. That in itself opens up a tremendous can of worms. that the courts should think that they have the right to go and look at the substance of a tenant's ERAP application. I don't see where the courts have that right. The legislature gave the power to an administrative agency to figure it out. How can the court step in and take over something that it was not given power for? That primary jurisdiction was given to the administrative agency. What would happen if OTDA says, yes, the tenant is eligible, but the court says the tenant is not eligible? Who wins? So I would stay away from the efforts to get beyond or inside the ERAP application itself and stay away from the argument that the tenant is not eligible for ERAP. There are some exceptions. There was a case where on Long Island where a tenant had another house that the tenant could have moved to. The court found that that was sufficient grounds to set aside ERAP as to the premises then before it. By and large, you're not going to get such wonderful cases where the tenant owns another house. So my opinion is you stay away from those. Mason versus Reyes, New York City, it said all the right things. The court has the inherent authority to control stays. CPLR 2201, I really don't know how CPLR 2201 affects the lifting of a stay created by another statute. Okay, but this court felt that it was applicable, that the court should interpret statutes to avoid absurd results. The absence of a meaningful way to challenge the stay would implicate due process, and the courts still have a role, I spelled role incorrectly, even though it is the legislature that sets public policy. But at the end of the day, it refused to lift the stay because it was not a holdover proceeding, and the ERAP application arguably would have preserved the tenancy. Gurovich versus Robinson, holdover proceeding. The occupant filed for, the tenant filed for ERAP, the occupant filed an appeal. Here, the court actually mentioned Judge Marks's administrative order, gave it lip service, but then noted that the AOs are subject to interpretation. Also noted that ERAP would not cover all of the arrears owed. So there, the stay was lifted, but primarily because it was a holdover proceeding. MH Rental versus Zani was a New York civil court case. New non-payment proceeding was the tenant had already received the full ERAP funds. Tenant filed a second application. Landlord had obtained the judgment and warrant and executed without having informed the court of the second ERAP application in violation of Judge Marks's administrative order. The court restored the tenant to possession based upon violation of the ERAP stay, since the landlord had no right to unilaterally determine that the tenant was not eligible for ERAP. Really? Okay? There's a very well-settled principle that courts won't restore tenants to possession, where ultimately all that's going to happen is the next week they get evicted anyway. But in this case, after saying all the right things, with all of the good facts in front of it, the court restored the tenant to possession. The landlord could either wait for the ERAP payment, if there was going to be one, refuse any additional funds, wait for a provisional payment. It's ridiculous. Absolutely ridiculous. Or move to lift the stay just to get back to where he was anyway. But you can I'm not going to read the rest of the quote, but they're good quotes. I think you should all take a look at them. Harmony Mills versus Constantine. Co-host, I love co-hosts. It's such a great place. This is a really good one. Found that the landlords have a due process right to test the tenant's ERAP application, at least where there is evidence presented to support a good faith reason that the tenant is not financially eligible for assistance. So they went all the way through. Rejected all of the other arguments put forward by the landlords, including Briggs and Acti, The court also would not accept the constitutional avoidance canon, which it felt was an unjust, alluring invitation to judicial mischief. Ultimately, he lifted the stay and allowed the tenant to be evicted. All right, what about what we don't have here yet? I haven't seen a case, by the way, where the stay was lifted after, under ERAP, forgetting aside the Yonkers case, where a court actually said, tenant already is in arrears for more than the 15 months. ERAP hasn't issued a decision. Landlord, you can proceed and evict. The only potential issue I see with that is identifying what months are due, because you don't know what months specifically would be covered by ERAP. So it would be impossible for the landlord to identify which months are still unpaid despite ERAP. But I think common sense would say that those applications should be granted, but I haven't seen one where it's actually happened. All right, so I dealt with all of the rest of this stuff. It is 1:15. Jim, do you want me to do secret memos, or do you want to go again?
Do we want to give the second course code now?
Second course code. So I'm just going to take 15 seconds. I see there's an Eric Weiss here. Eric Weiss, I was going to go with Houdini, who's Eric Weiss. But then I saw there was also a Myron Cohen. I had an uncle, Myron Cohen. There was a Myron Cohen that was a really funny guy. So my code is Uncle. Uncle is my code.
Thank you.
All right, Mark, why don't you talk about the secret memos case, and then I will discuss good cause eviction and local government manipulation.
All right. Secret memos. People who are following, at least in Westchester County, have probably heard that over the course of time, there were a number of secret memos that went out from OCA to the local courts through various other administrative judges. We found out about one of them, and that was partial of the basis for our action against Judge Marks to stop him from issuing secret memos, which also, by the way, went nowhere. A judge in Westchester County refused to do anything with it, found that it was moot because things changed. But anyway, although we got nowhere with it, the New York Civil Liberties Union found out that OCA had issued a secret memo to judges based upon a First Department case in the criminal arena, and sued served a FOIL request, which was denied, and then sued to enforce the FOIL request. Excuse me. Bottom line, out of all of that, OCA put in its memo of law a statement, aside from arguing that it was protected by attorney-client privilege and other privileges, said that, well, really, Judge Marks doesn't have, or OCA, doesn't have the power to tell courts what to do. And we all know that that's what happened. Every judge that was willing to talk to me about it said, I'm not doing it, not because I don't want to, but because Judge Marks told me I can't. And there are still certain courts that are doing things now that are not provided for in law, but there's an administrative order out there. So the Supreme Court in Manhattan actually sided with the New York Civil Liberties Union and has directed OCA to provide documents in response to the FOIL request. That's not due for 180 days. So I'm going to keep an eye on it, but 180 days is a really long period of time just to find out what the secret memos were. But if any judge gives you grief about this is what Judge Marks told us to do, let me know. I'll send you a copy or get a copy of the memo of law and show the judge. Even Judge Marks admits that he can't do that. Jim.
Okay. All right. I'm going to talk first about local government authority to interfere in the landlord-tenant process. And then I will go on to a proposed law, which has been issued in the or have been introduced in the last two terms of the legislature, which will create a fundamental change in landlord-tenant relationships. The reason I bring this up is because it almost passed last year. And there were stories in the New York Times about how good government groups, or at least groups that claim they're good government groups, were very disappointed that a good cause eviction law was not passed. Well, the city of Albany took it upon itself to enact a good cause eviction local law. And it says no tenant can be evicted unless good cause is shown. And the statute goes on to define, the local law, what good cause is. And one is non-payment of rent, then gets the tricky part. Unless or provided that the unpaid rent did not result from an increase or pattern of increases, which, regardless of tenant's prior consent, is unconscionable or is imposed for the purpose of circumventing the purpose of this article. And in determining whether there was an unconscionable increase in rent, the court could look at, and I'm quoting this now, it's hard to believe, but I'm quoting it, the rate of the increase relative to the tenant's ability to afford said increase, or the improvements to the subject unit or common areas, or significant market changes relevant to the subject unit. And the law created a rebuttable presumption that any increase in excess of 5% was unconscionable. So a few small landlords in Albany challenged this law. They argued that it is preempted by state laws governing, one, rent control, and two, eviction standards. There are two types of local law preemption in New York. One is called conflict preemption, where a local government cannot enact a law that conflicts with or is inconsistent with the state law. And the second is field preemption, where the state evinces an intent to occupy the field and assumes full regulatory control. And I cited a Court of Appeals case discussing those. Now, the court found this local law in Albany was invalid due to conflict preemption. And they cited three sections, one of the RPAPL, 711 subsection 1, which allows an eviction proceeding where a tenant remains in possession after the expiration of the term. They said it's a state law. It doesn't have a good cause requirement. It just says if your lease expires, you can be evicted. The second, real property law section 228, allows a termination of a month-to-month tenancy on 30 days notice. Again, it's not premised upon a good faith cause or a good cause showing. And third, RPL, real property law 226-C, allows increases of 5% or more provided adequate notice is given to the tenant. Once again, it's not conditioned upon a good cause showing. And the court found that the Albany local law would allow a tenant to, or a court to interfere in a lease relationship by deciding whether the increase is unconscionable. Set aside for a second the obvious problem. If a tenant cannot pay the rent because they lose their job, isn't that relevant to the tenant's ability to pay? So There are obvious problems with this law. Thank God the Supreme Court in Albany County invalidated it. They found that it preempts with, it conflicts with New York state law and is therefore void. I shepherdized the case, couldn't find any citing decisions, so I don't know if it's gone up on appeal. Last topic I want to talk about is good cause evictions. Like I said, this has been introduced in the state legislature the last 2 legislative sessions. It will be introduced again, according to the article I read in the Times. And what it says is that the law would apply to all housing except owner-occupied housing with less than 4 units. So you're not going to have a lot of that. You're going to have 2 and 3 family homes that are owner-occupied. So even a single family house that's not occupied by the owner is going to be subject to the good cause eviction law. Sublets where the sublessor, but not the landlord, wants to acquire possession for personal use and occupancy. The premises are incidental to employment where employment's being terminated. And the premises are subject to federal state regulation based upon a good cause eviction. Those are sort of Section 8 and public housing, where you can terminate a lease for good cause, such as the tenant is selling drugs out of the place. Now, one of the good cause to evict consists of the unpaid rent, except where the unpaid rent is due to an increase which is unreasonable or with intent to circumvent this article. There's a rebuttable presumption that an increase is unreasonable if it exceeds 3% or 1.5 times the consumer price index. That may not be a problem right now at this moment in time. 1.5% would be about a 13% increase in rent. But a lot of times when we had inflation running at 1 or 2%, that would be a pretty minimal increase that would be allowed. It would be presumed unreasonable if it was above that. The tenant violates a substantial obligation of the tenancy, but only where the tenant receives a 10-day notice to cure, fails to cure, and the tenant is committing a nuisance, maliciously or negligently damaging the housing units, or is interfering with the comfort of the landlord or other tenants in the same or adjacent building. Again, these are obvious grounds for eviction, but it puts a lot of additional burdens on the landlord. The court must find the violation, that there must be a violation. So we're dealing with code violations and things like that. Since I want to get to a few questions, I want to just go on and say, just look at the outline. The outline summarizes the law, which I suspect will be introduced. It will be a sea change, though, in landlord-tenant practice, that a person is required to, in a sense, allow someone to stay indefinitely, as long as they want to stay, even in premises that they own. And think about this. What if a co-op were to increase maintenance by 5 or 6% one year to cover a major capital improvement or just to cover inflation? That would be presumed unreasonable under this law. So if any of you have friends in Albany, call them, tell them this is a bad idea, don't do it, et cetera, et cetera. Okay, Diana, you want to?
Sure, we'll get to a few questions. Let's see. In a commercial holdover, is notice 90 days or 30 days if a tenant is in premises over 2 years?
I think that when they changed the law, originally they realized that 232B in outside of New York City would still apply to commercial tenancy. So it would only be 30 days. The whole 30, 60, 90 days applies only to residential tenants.
Okay.
I agree with that.
It sounds like a landlord can proceed with a non-payment eviction where ERAP fails to pay the entire amount due under the petition. Is this the case?
Okay, could you read it again?
Sure. It sounds like a landlord can proceed with a non-payment eviction where ERAP fails to pay the entire amount due under the petition. Is this the case?
Well, that's supposed to be the case. So presume that your petition has been sitting around for a while and gathering some dust, and ERAP all of a sudden comes along and pays whatever they pay. You should compare what ERAP pays, because they specify the months, to what's in your petition. So if you're in, let's say, New Rochelle, where I was this morning, the judge, if the ERAP payment covered every month that was in your petition, you're going to be dismissed. White Plains and some of the other places would probably allow you to amend, which makes only perfect sense, considering that you were stayed from amending all along in the first place. But if you have, even in New Rochelle, if you have anything that was not covered in your petition that was not covered by ERAP, you should be okay.
Okay, next question. Are judges able to refuse to so order a stipulation of settlement that is entered voluntarily when there is a pending ERAP application? I have run into this problem occasionally. I am not aware of any law that requires in the normal course that a judge so order a stipulation. And I know a lot of judges who refuse to so order stipulations as a regular course. So if you want it so ordered and they're refusing to, you may not get it enforced down the road, but there's no requirement that they do it. They have every right, forgetting about ERAP, they have every right to refuse to, which begs the question whether a tenant can waive its rights under ERAP, which I'm a firm believer in. There's nothing in the statute that says that any agreement that would waive a right under the statute, which you find, let's say, in the warranty of habitability statute, you don't find that same language in ERAP. So a tenant should have every right to waive the rights, and the judge should go along with it, especially if they're right.
Yeah, I agree, Mark. That language is in a whole bunch of laws. It's in the roommate law. It's in this proposed good faith or good cause eviction law. It's in the security deposit law. It's all over the place. So the legislature leaving it out, to me, is making a statement that a tenant can waive their rights under ERAP.
Well, I think they just forgot to. I don't give them that much credit.
Okay.
We'll go maybe 5 more minutes, and then we'll and so we end pretty much on time. Is it true that after ERAP payment is Is it true that after ERAP payment is received, you can still evict for new or future rents due that are not paid after ERAP was received, regardless of the 12-month non-eviction rule?
Yes. But what you might find is that the tenant, when you do that, the tenant files an appeal or a new application under ERAP if the tenant had not received the full 15 months in the first place.
Okay. Let's see.
I'm sorry, Jim, I did that one.
Yeah, just fine.
In a residential squatter situation, if the squatter has been there for under 1 year, is a 30-day notice necessary?
Squatter gets a 10-day notice under RPAPL 713. It's not a tenant, so they're not entitled to the 30, 60, 90 notice of non-renewal.
Gotcha. Have there been any efforts to include pandemics in force majeure clauses allowing commercial tenants to terminate their leases? I know that the courts were rejecting the force majeure argument because pandemics were not specifically included and presumably foreseeable.
I've heard of a few cases where that's happened, but most commercial landlords aren't going to want that because they see what could happen. But if it's not in there, the question is correct that every major case is the first department came down with a decision in last year, I think, said can't do it. It doesn't. So you can try, but
that's a matter of negotiation between the landlord and the tenant. And having just worked on our new lease, landlords are very reluctant to entertain substantial changes. They allowed us to tweak the language a bit, but they would not allow a pandemic as a force majeure.
What is the time frame to get squatters out compared to actual tenants?
Well, so again, the squatter gets a 10-day notice. A regular tenant might get some other kind of notice. It could be a notice of termination under the tenancy, or it could be a non-renewal. That's just the notice part. Once you get to court, it's basically the same process. You still got to bring a petition, still got to go through everything. The tenant's still going to ask for time to get the squatter will also ask for time to get a lawyer. You get a German stare. The squatter might file for ERAP and hope that you're in a case that's willing to lift the ERAP stay because the squatter is not a tenant. So yeah, they might not get all of the emotions that a tenant gets, but still gonna get some of them.
We'll get to one last question. Can owners lock out commercial tenants who do not pay the rent? Has this changed?
I believe it changed in 2019 when they adopted a brand new version of the wrongful eviction. It used to be called wrongful eviction. It's now called unlawful eviction. And it covers even mistakes where a warrant is issued by mistake by the court or based upon incorrect statements in a petition is now considered an unlawful eviction. So you cannot just lock a commercial tenant out anymore. You do so at severe risk to yourself.
I have one caveat to that, because Jim is correct that it was the HSTPA that changed all of that. In my outline, which I didn't get to this part, there are a couple of cases out there that indicate that HSTPA is limited to residential tenants, even if it doesn't say that specifically, which means that the old law for a commercial tenant, you might still be able to do, and if you gave the proper notice, you could use self-help against a commercial tenant. But as Jim says, it's an uphill battle, but there is a good argument, I think, to be made that you can still do it.
Okay. Thank you both so much for your time, Jim and Mark. A great lecture as always. We do have a CLE coming up in November on loft, law, and zoning, and then in December we will have a 1-credit ethics CLE. So I'm getting ready to brainstorm what we're going to bring you in the new year. So if you have any suggestions or you would like to speak, please reach out to me. In any event, we will see you in November. And once again, thank you for a great CLE. Oh, Mark.
I'm sorry. I know I didn't get to my part about HSTPA, which is fine. But if anybody has questions about the things that I dealt with, find my email, and I'm happy to answer anything.
Yeah, the same with me. Any questions anybody has on any of the topics I covered, feel free to send me an email and we'll respond to them.
Great.
And thank you everyone for attending.
Thanks everyone. See you soon.